Thank you everyone for joining Mayor Brown's Technology Transactions Practice webinar. Our program today will focus on governing service provider relationships, tip for protecting your deal after the ink is dry. We'll cover a couple of administrative matters first, and then we'll get started. First, this is a presentation by our Technology Transactions Practice, which helps with transactions involving data, digital services, outsourcing, and software. We will be scheduling periodic calls and webinar programs on technology transactions topics, so please watch your inboxes for future invitations and feel free to spread the word to others who might be interested. You can also find many past programs on the Technology Transactions webpage at www.mayorbrown.com. Our goal in these webinars is to provide practical and strategic advice to help you secure high-value technology contracts, improve operations, build digital platforms, and achieve compliance. During today's presentation, you will be provided with an alphanumeric code. If you are applying for CLA credit, you will need to record this code on the virtual sign-in sheet that you will receive by email with the connection details. You will find directions for returning that virtual sign-in sheet on the virtual sign-in sheet. We will read the code in the middle of the presentation and then again at the end of the presentation, and the code will also appear on slides in the presentation. We also plan to allow time at the end of the program for questions. To submit a question electronically, please use the Q&A panel in WebEx. If we don't get to your question during this webinar, we will make every effort to follow up with you after this webinar. This webinar is being recorded, as we normally do with these programs. In a day or so, we will be sending you an email with a link which you can use to listen to the webinar again or share it with your colleagues. The recording will also be posted to our website with a collection of past webinars. My name is Brad Peterson, and my picture is at the bottom of the slides, and I'm delighted to participate with my partner, Bob Kriss, on today's topic. As many of you know, I'm a partner in Mayor Brown's Chicago office and the leader of our Technology Transactions Practice. I'm very pleased to introduce my fellow presenter today, Bob Kriss. Bob is a litigation partner in Mayor Brown's Chicago office. He's handled many technology and internet-related disputes and has substantial experience with mediation and arbitration and other forms of alternative dispute resolution. He has tried cases before judges, cases before juries, and cases before arbitrators, and has served as an adjunct professor of trial advocacy at Northwestern Law School. I also know from my own experience that Bob provides excellent practical advice to customers in resolving disputes and bringing them to successful conclusions. With that brief introduction, let's get started on today's program. As those of you who work on commercial transactions and technology transactions for customers know, protecting value after the ink is dry is about motivating suppliers to deliver on their promises and preserving remedies for failure. That is our focus for today. The problem that we see looks like this. Time and money are spent on drafting the contract, and often a substantial amount of money by a large team of very dedicated people, and a tremendous amount of potential value is created in that contract, and that value must be delivered throughout the contract relationship through the governance process. But the contract is then turned over to a well-intentioned supplier relationship management team that often does not understand the contract. That's not surprising. Contracts are difficult to understand, particularly if you don't understand the underlying legal system, or you haven't been part of the contract negotiation, or you haven't received training on it. And relationship managers are often selected based on their knowledge of the subject matter of the contract, the particular technology, or their skill at building personal relationships, not at their understanding of how to run a contract. Further, the people managing the relationship often do not understand how their communications and conduct can affect the company's legal rights. They haven't been through the process of working through a contract in a court. They haven't seen how this unfolds. They may not realize that omission and oversight and delay often favor technology providers. Meanwhile, technology providers are specialists in delivering their particular technology, and often they are specialists in working a customer organization to achieve good results. What's the result? Contract benefits for which you negotiated hard and are paying great amounts may be lost. Disputes arise that could have been avoided, and disputes result in losses that could have been wins. So today's agenda is to see if we can find ways to help you, either as lawyers who are advising contract managers or as contract managers, achieve better results. And we're going to start with a hypothetical case study talking about some common governance challenges that we see, fact patterns that we see again and again, and talking about the way we see them unfold and then what might have helped. Second, we'll provide 7 tips for managing provider relationships. We think these tips are so powerful that they should be on a laminated card at the contract manager's desk. And finally, we'll make the case for clarity.
Good morning, everyone. It's Bob Kriss. Our case study is a hypothetical, but as they say in the movies, it's based upon actual events. So let's assume that last year a customer and a provider entered into a contract that had 3 principal components. First, the provider agreed to run the legacy systems of the customer. Second, to transform certain databases. And third, to implement a software product in the customer's IT system that will provide new functionality. Just a year into the contract now, and the customer's team has already identified 4 serious problems. As to the legacy system operation, there are so many problems and trust issues as a result of those problems that the business wants to terminate the relationship based upon material breach now before it suffers a business catastrophe. As to database transformation, the project is far behind despite heroic efforts by the customer's team members to help get the job done. As to system implementation, the new system isn't meeting the customer's needs, and it's just performing too slow to be practical and useful. And finally, as to data security, there have been systems developed, but those systems are not consistent with the customer's understanding of what best practices in the industry are, and the customer wants to be consistent with best practices. So those are the 4 challenges that we're going to address as we go forward to illustrate various points. So turning to the termination of legacy system operations. Here's how a conversation between a customer and provider might go if the customer had not been careful to protect its deal after the execution of the contract. The customer might say, you know, as you know from what we've been talking about during our weekly meetings, your performance has been very disappointing. There have been a series of serious shortfalls in your performance. They threaten our business, they threaten our reputation. We really can't trust you anymore. There's too much at stake with our business, and we don't know when the next breach is going to happen that could very, very seriously harm our business. So we've decided to terminate the relationship for material breach, and we expect you now to cooperate and pay our costs of moving the relationship to another provider. In response to that, a provider might say,
well, you know, I'm shocked because we've had some difficult discussions, and, you know, a great relationship requires great conflicts, and we've worked together. We don't think there have been any performance problems. And, you know, look at the record. You've never sent a breach notice. We've sent you a status report every week with a dashboard with 15 items on it. Our dashboard has always been straight green lights. This is not a case, you know, if our performance has been bad, we understand, but this is not a case where our performance has been bad. This sounds actually like a case where you've had a change of heart about this project, and we understand that customers have a change of heart, a change of business needs, and now you'd like to go in another direction. But we just need you to be, honest and upfront about it and terminate for convenience using the termination for convenience provisions and pay the termination charges so that we can recover the loss from your change in decision.
Okay, so obviously difference of views here. How could the customer have put itself in a better position to terminate the agreement? We offer 5 thoughts. First, we recommend that you send written breach notices when the concern first develops and after each subsequent breach. I want to emphasize these breach notices, the tone can be polite. They should be firm but polite. You're basically just asking the provider to deliver what the parties agreed to. So you're pointing out where they failed, and you're asking them to improve. It's management. It's not World War II. Otherwise, if you don't send breach notices, the CEO of a provider who's brought into a dispute doesn't have intimate knowledge of it, but now has to decide what to do, or a judge or an arbitrator if the dispute isn't resolved, they may all conclude that if the breach wasn't serious enough for you to send a written breach notice, then it just absolutely isn't serious enough to justify terminating the contract for cause. So you absolutely have to create a record, and it ought to be created from the very beginning as breaches arise, so that it is understood to be part of the regular practice of managing the contract as opposed to something unusual and threatening. Second, each breach notice should request that the provider deliver a root cause analysis as to what went wrong here when the events are fresh. Why? Because then the provider has a better shot at fixing the problems. And second, it also minimizes the possibility that the provider will try later when a termination is imminent, or after termination when you are in dispute resolution, may later try some revisionist history and blame all the problems on the customer. Instead, if you've asked for root cause analysis along the way at a time when it was less threatening and you got candid, honest assessments of what was at fault or who was at fault, you are in a much better position to make your case. And if the provider indicates in a persuasive way that the customer is the problem, then the customer can change its conduct, and the relationship can improve, and the performance will improve. Third, I'd like to stress that it's really important to think of a notice letter not just as a technical exercise where you cite a section of the contract and you say you breached this, do better. You should provide enough background in the notice letter so an outsider can understand what happened and why it matters to the customer. What kind of an outsider? Well, like I said, it could be even the CEO of the provider who isn't intimately familiar with this relationship but is brought in to assess what the provider should do. He can read a notice that makes sense to him, and it may be persuasive to him, and that will help you get the transaction back on track. Or if it's into dispute resolution, a judge, a jury, an arbitrator, they can look at a notice, understand what's going on, and be persuaded that this matters, that this is important. Also, if you provide background in a notice letter, that implicitly invites a response from the provider, or sometimes not implicitly. Sometimes it can be part of your notice letter to actually ask the provider to respond. And why is that a good thing? Well, one, if there is no response, then that is essentially an admission that you're right. And now you have developed some useful evidence if ultimately you have to litigate this matter because you made an assertion, you explained how it was important to the company, and they didn't dispute it. Second, if there is a response, it may be informative. It may help the customer figure out what it needs to do to make things better. Third, if there is a response, there can be a series of letters, notice letter, response, maybe a reply, maybe another response, and in 2 or 3 letters, you can basically lay out all the relevant facts of the dispute. So if there, again, is a dispute down the road, or if the CEO needs to understand what's going on to resolve a dispute, you can focus on 2 or 3 letters, and it lays everything out, as opposed to looking through thousands of emails, piecing them together, and try to reconstruct, what the facts were at the time. Furthermore, if by going through this process, you minimize the risk that you're going to be surprised if this matter does ever end up in litigation, because if the provider does not identify a problem in a response to a notice, it's very problematic for the provider to later argue that something's important that wasn't important enough to put in the letter responding to the breach notice. Another point, object in writing if there are incorrect statements from the provider, including in status reports. There should never have been a green dashboard here. It should have been red or yellow. There should have been some words in the status reports that made it clear that there were problems that had to be solved. Silence in the face of assertions often is deemed to be an admission. Finally, if you're not satisfied with the way things are going, before you pull the trigger, you really should have a notice that makes it clear what is the threshold where the trigger will be pulled the next time. What is it that, what type of breach is it that in your view will be the end of the road? And why is that important to you? It should be laid out in the letter. And if there's no response by the provider disputing that your threshold requirement makes sense, is material, does affect the company, and they still fail to meet that requirement and they breach again, you'll be in as solid a position as possible to argue that it was truly a material breach. You would have defined essentially what is a material breach. Sometimes the material breach is defined in some pretty objective, almost quantitative terms in a contract, and if those apply, termination for material breach is more straightforward. But often either that definition isn't there, or what is happening, as in our hypothetical, a series of things happening may not fall within the objective quantitative formula, but be subject to the more general principle of law about material breach, which is a very general standard. Does it go to the heart of the agreement? So you have to sort of create what that heart of the agreement is in written communication with the provider before you, in fact, pull the trigger.
Let's go to our second part of the hypothetical case study, and this is a bit of a success. Let's talk about how the conversation might go on this database transformation, big, urgent project in the new big data world. Customers are looking for a much more effective, faster, higher performing database which incorporates numerous kinds of new input. And let's say the customer sits down and says, okay, this is great, we finally delivered, the new system is on, we just need to sort everything out, we've got your invoice for the big fixed fee, and so let's just talk this through. As you know, you failed again and again and again, and we knew that we were going to miss milestones, and you knew how urgent this was, and we kept adding people to this project, and we added people in absolutely critical roles, including some leadership roles. And, frankly, we got the sense that your people just stepped away as we stepped in. Now, thanks to us, it's working. The project is a success. But the cost of all those people that we added to this project has been substantial for us, and we can't ignore it. And as a result, what we've done is we've totaled up the fully loaded cost of each of the people involved, and we're going to be deducting that from your this new final invoice that you've submitted.
Well, you got to be kidding. this is revisionist history. I mean, we agreed to partner on this transformation according to the procedural manual that was approved by your staff. Didn't you read the procedural manual? That laid out how we were going to work together, and that's what we did. Your people were required to work with our people, and in fact, the project was delayed because your people didn't provide information in a timely way. So, I mean, you chose your level of collaboration. You agreed to the process and the procedural manual. The project's a success, that's great, but you know, don't look for additional fees from us or some sort of compensation. I mean, that just wouldn't be fair. I mean, now that the work's all done, you raise this for the first time.
This could be an expensive problem, so let's talk about how we might have avoided this. What might have been a better approach? Step one. The customer could have sent a notice at the start identifying one or more customer's representatives authorized to speak for the customer on contract topics. The provider, as Bob said, has a great point, having put out some clarity in a procedures manual and getting it approved by some member of staff, and which wasn't objected to on our side, set the bar at what level of collaboration was actually required. Second piece, we needed to develop at the very start of this a clear view of what our responsibilities were as customer and make sure that that's understood by everyone on the team. Because one theory is that we did what was necessary heroically to save the ship as it was sinking. The other theory is that we kept tossing in people who pushed the supplier aside. And given that we're looking at it in the past, in retrospect, it's very hard to prove. But if we'd started by saying, let's be very, very clear and let's establish a record up front about who's going to do what and how much time it will take, we would have been in much better shape. Third piece, we think that we're providing resources which the provider is requesting. And of course, it's a fixed price contract. The provider will request a lot of resources. What we didn't do in this case is require that the provider maintain what I call an evergreen log that's accessible to that customer authorized representative, where the provider enters a request, every request that the provider has, and when answers or new data are required to keep on the schedule. So if we had done that, it would have been either we would have solved the problems in advance, or we would not be facing a provider who's saying your people caused the problems by failing to do what they agreed to do. We'd have a record, one place to look. Fourth point, obviously there was a problem in not having an authorized customer representative who was the only person who could approve a procedures manual, but there was also a problem that staff members, obviously working hard to do their job and to help, had approved a procedures manual. And if they had been guided to assign that to the customer authorized representative, it would have gotten better review. There might have been substantial objection to the allocation of collaborative responsibilities and so forth. In any event, there wouldn't have been the risk that the provider, being clever at working the customer organization, found the person most likely to simply sign off. And then finally, probably most importantly, here's the more of a legal point. We should never do the provider's work except after giving notice to the provider, as Bob described, providing an opportunity to cure, and a reasonable opportunity to cure the breach, providing some sort of notice of the failure to cure, that second chance that Bob talked about, and saying in a notice that we're planning to add resources as a way to mitigate damages, or that these resources are being added, but with a reasonable expectation that the cost of the resources would be deducted in a final true-up analysis from any fees.
Okay, so now we turn to the scenario where a new system implementation isn't working out well, and the customer wants to stop the project, get a refund for the failure of the new system to meet the customer's requirements. Brad and I have been there before, and we've been brought into situations where the conversation between the customer and provider, when something like this before we got involved, the customer tells the provider, you know, look, this new system has serious issues. The functionality isn't there, and most significantly, the performance isn't there. It's just too slow. It can't be used. It's not practical. We've been working with you for months on this, and we still have software that doesn't do the right things, and whatever it does at the speed of molasses flowing through a filter. So, you know, we can't use it. We gave you a chance. We want to stop the project and get a refund.
Well, this is simply incredible, and by incredible I mean not credible. First, you said that the software doesn't do the right things, but if there are problems, it's that we have changed good software that we provided as a base software with numerous requirements that you raised. And then this idea of performance requirements this is even less credible because there are no performance requirements in the contract. Nowhere in our extensive discussions about functionality did you describe performance requirements. So we believe that there are simply no performance requirements as part of scope. And then, you know, our software works, our base software works. Your engineers have worked with us and we've got a lot of email history where your engineers have questioned whether our software is to blame. It might be that the network traffic is too high. It might be that there's not enough equipment. It might be operating system problems. There are a lot of potential causes, and your own engineers are making the case that our software works.
All right. Well, how could these problems have been avoided, or how can they be addressed now since they weren't avoided? Several points. First, move on. Okay. Very important at the beginning of the process, in the contract, or if it's not in the contract, in writing in your early requirements gathering meetings, to define minimum requirements, particularly performance requirements. Why is that so? Well, if you have clarity at the beginning, it's going to help you get the job done right, because there often is a relationship between the functionality you are requesting and the performance that you need in order for it to be practical. And if everybody has their eye on the ball and knows what the performance is, then if some functional requirements come up that are not practical, somebody can raise their hand and say, this can't get done. And the chances of the project being successful are greater. But second, the beginning of the relationship is the time to address things that are not pinned down entirely in the contract, because the parties are friendly. There is no problem looming over them that is going to chill the discussion. They will act more reasonably, and therefore at the beginning is when you determine, you know, what is a reasonable performance standard, for example. I have seen contracts that say the parties will mutually agree to reasonable performance criteria as part of the acceptance process down the road after the ink is dry. Well, there are problems, legal problems, with enforcing an agreement to agree, but there are also very practical proof problems of determining what is a reasonable performance level. Sometimes the contract refers to industry standards, but I can tell you that often there are no industry standards to refer to. So the best solution is agree up front when things are not contentious. What is the performance criteria that's reasonable? Put it in writing if it's not already in the contract. Second, require in a writing to the provider that it notify your authorized customer representative if the provider feels that the customer is interfering or delaying the work in any way, for example, by changing the requirements or adding requirements. Why is that important? Well, If it is an issue, you need to know about it. The authorized representative of the customer, who's presumably the high-level executive, needs to know about it so that the customer conduct can change and things can get done properly. But it's also important because you don't want a situation where months go by, things aren't getting done, all sorts of problems exist, and you are seeking to stop the project, get a refund, and you hear for the first time, no, it's all your fault. You're changing things. You didn't give us the information we needed, and you hear that all at the end. And then you have to sort out, is that true? Months after the fact, go through thousands of emails, interview people. Instead, if there is a requirement that problem be noticed in writing to the authorized customer representative, or you're going to presume there's no problem whatsoever, then you have a manageable situation that forecloses this revisionist history. Next, you got to brief your customer team on avoiding harmful speculative statements about what is causing the problem. Often you don't know yet what's causing the problem, and if your people are speculating in loads of ways in internal emails, all of that can become evidence in a proceeding. Use change control procedures with agreed change orders showing the effect of each change. And request in writing that the provider make available test data that shows that the standard software meets performance requirements. Brad and I worked on a matter where years went by and the system wasn't working, and the answer that we got from the provider was, well, all these change requirements are causing problems, and you change them, and now this is something new, and it's all the customer's fault. This is what we heard when we were brought in. And it occurred to us, well, maybe there's something wrong with the standard software. It's a new product that this software developer is providing. So we asked in writing that the software developer provide data showing test results that showed that the standard software met the performance requirements. And there was absolute silence. There were no test results. The provider was actually using our client as the test case. And that ultimately became, that exchange, our request and their lack of response were the beginning, were the subject of the beginning of my closing argument in the case. And the tribunal determined, in large part because of that challenge to produce test results and the failure to produce test results, that this problem was not caused by the customer. It was caused by software, standard software that never was properly done. Finally, if the first go-live date is missed in a project, you should seriously consider providing a second opportunity before you pull the trigger, but only with conditions. And those conditions should include that the supplier provide a root cause analysis in writing, explaining what is going wrong here and who's responsible for it. And also written assurances as to when the project can then be completed. And probably you will have to agree and should agree to freeze any new requirements during this period of time. But with those conditions, a second opportunity is a good thing. And if they miss that second opportunity, you are just in such a much better place to enforce your rights, to stop the project, and to get a refund than if you pulled the trigger after the first go-live was missed.
So, fourth case study example, let's just take an easy one here. One of these places where there's one of those minimum performance requirements that Bob talked about, that just a clear material breach if it's not met. The contract calls for you to implement reasonable and appropriate data security in all services and systems. Those words are, they're so standard, they're used in statute after statute. It turns out we had an audit done and our auditor says doesn't meet it. We hired an industry consultant who actually sells some of the top software. They said, no, this isn't close to reasonable and appropriate. And You know, we've got regulators who have made some statements in important forums that say that, you know, we need better security than you're offering. So this seems like a clear case where you should be upgrading the security of the services and systems at no charge to us.
Well, I don't think it's such a clear case, and in fact, I don't think it was such a clear case to your own people, because let's look at the history here. Your own people came to us and asked us for a budget estimate for a new system. Only after they got a budget estimate that they didn't like did they start taking this position. I mean, actions speak louder than words. Your folks understood that this was something new, something outside of the scope of this agreement, and that's why they sought a budget for the additional fees. You know, look, we'll do anything you want, but we're not going to be doing it for free when it's outside the scope of the agreement.
This sounds like this might be expensive. How could these problems have been avoided? Well, as we've talked about before, getting clarity at the very start would be very valuable, and sending notices to surface any disputes like this as quickly as possible would be valuable. So in this case, for example, the customer could have sent a copy of its information security policy and insisted that that be part of the contract and reasonable and appropriate. The customer could have sent copies of the laws or the regulator statements and so forth, and early on in the contract had those requirements detailed out. But the real self-inflicted wound here, the error was letting the customer team ask for a budget for new work before you decided that it was not new work. So one thing to do is to make sure that nobody on the customer team asks for budgets for additional work without consulting that authorized representative, and then make sure that the authorized representative has a tag to go back to whoever might be appropriate, and I think the law department is probably a minimum there, to make sure that the work is not required. And often, for example, someone looking at the contract will say, well, I've looked through the statement of work, I don't see anything here, and the lawyers might say, well, perhaps you should have taken a look at the information security warranty or the commitment to our information security policy, which included these precise procedures. And now let's go to the next portion of our presentation, 7 tips to protect your deal.
All right, so we've offered a number of ideas for how to protect your deal, illustrated in the context of a hypothetical but realistic case study. Now, what we've done is distilled and summarized these ideas into 7 tips, which we're going to discuss next. And I will also point out we can and will be happy to provide you with a laminated copy of the tips for your IT staff to have at their desk as reminders of some of these basic concepts. If you just send either Brad or me an email, we'll make sure you get as many as you need. So the first tip, control messaging and contractual communications. To achieve that kind of control, we are recommending that you designate in writing to the provider all the customer employees that are authorized to speak on behalf of the company for purposes of the contract. We've given you sort of a brief skeletal example of language that can be used for that purpose. We have examples for some of these other tips as well. We won't go through those in detail, but they're there for your reference. What's the benefit? You avoid the inadvertent unfavorable change to your contract that occurs, for example, when lower level people who aren't familiar with the contract are approached by the provider to approve a procedural manual, for example. And they do. And that procedural manual ends up really changing all of the obligations of the parties. But nobody who really understood the contract was involved in that process, and they signed off on the procedural manual. You don't need that to happen, and it doesn't have to happen if you make it clear up front in writing to the provider who represents and can bind the customer. And that's just good for the relationship, because that will result in fewer misunderstandings between the parties, and with fewer misunderstandings, that promotes a better relationship. It also reduces the cost of dispute resolution because instead of examining, dozens of email boxes and thousands of emails, you basically go to one or two people's email box and say, well, is it there? Is there something that changed this relationship? No? Okay, we win. So it's very important from that standpoint as well. And it's important to keep in mind that if you are controlling the message, you want that authorized individual to also be directing the team to be acting consistently with the message, because actions do sometimes speak louder than words. Contracts are interpreted based upon a course of performance, which means, what did the people actually do? Did they send a budget request? What does that mean? That means that they think that it was outside the scope of the agreement. So you want to control the message internally as well, so that you don't have your people acting in a way that your counterparty can argue means that everybody was interpreting the contract in a way that you didn't really want it to be interpreted.
Second tip, require a log of provider requests and notice of any company failures. In most procurement and sourcing contracts, the customer's obligation is just to pay. However, technology transactions are different. When you are involved certainly in transactions like outsourcing, software development, collaborative development, design, data licenses, software licenses, service integration, the digital services such as cloud, artificial intelligence, robotic process automation, machine learning, and so forth, these are in some ways collaborations. As a customer, the customer will tend to have obligations. And if the customer doesn't perform those obligations, that may be an excuse of performance. So, two things you can do. The first is require a log of provider requests, hopefully an evergreen log that you keep up to date with what requests have come in and have they been fulfilled. And then second, make sure that the provider understands that it needs to quickly identify in writing to an authorized employee any of the customer's actions that might be seen to excuse or harm a provider obligation. In a perfect world, the contract states that none of the provider's failures will be excused unless the provider notifies the customer of the problem, gives the customer a chance to fix it, tries to perform despite that problem, and verifies that that problem caused the provider's failure. But even if it doesn't, you can establish, as Bob said, requirements like that through good, sensible correspondence.
Third tip, keep the written record as clear and complete and accurate as possible. As we discussed, you want to clarify parts of the contract that are not clear as soon as possible in the relationship in writing. That's the best time to reach agreement because the parties are the most open to cooperation at that point. And you have to be sensitive, and your team has to be sensitive at all levels to the importance of responding to a provider that makes an incorrect assertion by sending a written correction back to the provider. Otherwise, silence may very well be deemed an admission, and you're going to have to live with the provider's version of the facts. A dashboard should never be green if a provider's performance is not meeting performance requirements. And also, if you are going to be collaborating on a project, and let's say that collaboration isn't spelled out in the body of the main agreement because this is a more granular project, make a summary of what each party's responsibilities are and have that signed off on before you embark on it so that you can sort out who's responsible for the problem if a problem arises. At the end of the day, cases, if there is two things. At the end of the day, if there's clarity in the written record, the likelihood that the situation is going to get worked out in the context of the outsourcing relationship is very high, much greater. And if it doesn't get worked out, then in a dispute, the writing is what matters so much. Testimony about oral conversations often discounted, but the writings are key, so they have to be complete and accurate.
Tip 4, send timely breach notices. Breaches should never be ignored. if the provider breaches, send a written notice including enough information so that an outsider can understand the breach and why it matters to the company. Now, one of the themes we see is that we say, so you had terrible problems, you've been having terrible problems for a long time, why is there no record of this? And they say, well, you know, it would be awkward, it would be unpleasant, it seems contentious, we're trying to have a good relationship here. They're going to say, you're pulling the contract out at me, it seems very hostile, and what we need to do is have a good, effective working relationship. I think a fair response to that, and particularly as governance teams are being trained, is this needs to be a standard best practice that the company always uses, and ideally it begins early on in the contract. There are always a goodly number of breaches to try it out on early on in a contract, where you send polite, reasonable, directed conversation in the same way that you would send a message to a friend saying, what you're doing is not what you promised, and it's causing me problems, and I want you to fix it. And if you can establish that pattern, and particularly by having a single person who feels comfortable in that part of a relationship, sending regular, polite, not hostile notices that are clear and useful, you'll establish a much better record.
Okay, fifth tip, before doing the provider's work, demand that the provider do its work. This is what we talked about, you know, in terms of the transformation example. You don't want to add resources and assume direction of a project that the provider should be doing without giving the provider a notice of a breach and an opportunity to cure, and a warning that if it isn't cured within a particular period of time, there's going to be action taken, and the customer is going to be looking to the provider to pay for the cost of that action. That's just fair. It's just fair to the provider, and what's fair really matters when you're in the context of dispute resolution. So if you're going to be taking things over and adding people and then coming back after that fact and say, you know, you didn't do your job, now pay up, that just is going to poison the relationship, and it also is not likely to fly in any kind of dispute resolution context.
Sixth tip, trade waivers for future assurances. If someone asks you for a waiver on a breach of a credit that's due, et cetera, find a way to trade that. Now, well, it may be worth just preserving your remedies or taking the credit and so forth, and that may send a powerful message. But if you don't want to do that, the job of the contract manager should be to make win-win trades, value-added trades, and find ways to, for example, trade you might trade a waiver of a performance credit for a larger assurance on a future milestone, or perhaps a new milestone, a root cause analysis to show what actually went wrong, and a demonstration that that's actually been corrected, or other concessions that lead you to a stronger contract. And the benefit of that is that you increase the chance of a successful outcome, and at the same time you build a stronger relationship, one of accountability and trust and mutual understanding, where it's not that you're granting favors in the hope of future favors back. It's that you are very directly preserving your company's assets by trading one obligation for another. Finally,
involve lawyers early. It may sound self-serving, but we have seen time and again how an ounce of prevention can avoid a pound of cure. Lawyers can find rights that are not apparent on the face of the contract. They can help to resolve issues more successfully. And communications with the lawyers and the customer team can be privileged, so there can be a full discussion of the problem that can lead to a better outcome, because everybody can be candid with each other internally. And it's just really important to create the right record, written record, to establish your legal rights. And lawyers, and I would say particularly lawyers who have been involved in dispute resolution, have an eye and an ear for evidence and how documents will play in front of a judge or jury or any other dispute resolver, mediator, and they can be very helpful in essentially creating evidence that is helpful to the resolution of the matter, either through a settlement or through dispute resolution if the settlement can't be achieved. And we've listed a number of examples of when to involve a lawyer here. You know, when there are signs of potential dispute involving the breach of the contract, and when the provider asks for new charges for what you believe to be in scope, really important that you create the right record there, because as we talked about, course of performance can affect the interpretation of the contract. So you want to make sure that both the communications and the conduct of the customer are consistent with the contract rights that the customer wants to enforce. Otherwise, you may suffer as a result of the mixed message that you give. When amending or modifying the master agreement, of course, lawyers are important there. Before contributing resources to a joint project beyond what the company had agreed to contribute, we talked about that in the collaboration, the transformation example that we gave. Before threatening termination, litigation, or self-help remedies, as we talked about termination, you really need to create that written record with breach notices and a notice that has enough of background so that it's understandable and persuasive. So you write it with an ear to how a judge or arbitrator might understand the situation. And when receiving correspondence threatening a claim, of course, the response is critical, because if you have correspondence threatening a claim, your response is essentially going to be evidence. Could be used as evidence for you or against you, depending upon you know, how you structure your response. So lawyer participation there is very important. And finally, when hearing that a provider has been sued by a third party, that could be a kind of a red flag that something's up here and you need to have a strategy on how to deal with the provider in light of the fact that others are now suing it or threatening claims. So as I said before, these are 7 tips. We have them in a concise form, laminated card, kept by an IT employee's desk so that they can refer to it and remind them of some simple points that can pay huge dividends in avoiding trouble or turning potential losses into wins. So what is our final message? Final message is clarity is a win-win. As you see, each of the tips that we've talked about promotes clarity. Clarity in terms of what the parties' respective obligations are, and clarity as to what has happened or what's expected to happen. And with that greater clarity comes greater certainty as to how a dispute will be resolved in court or arbitration if the parties don't settle. That greater certainty increases the likelihood that the dispute will be settled, or if not settled, fairly adjudicated. Why? Because if both sides have the same idea regarding the likely outcome, because things are clear, there really is no point in litigating. You should be able to settle that case, because the parties will be pretty close in valuing, you know, what the likely outcome is, so avoid the litigation. And if for some reason you can't, the record will be clear, and you'll have a more successful outcome. It also, as we've talked about, reduces the cost of dispute resolution, because it generally reduces the amount of effort necessary to prove the relevant facts. As we talked about before, if you have a breach notice and a response, you can basically prove your case based upon what was asserted, what was the response. It lays everything out rather than hunting through hundreds or thousands of emails trying to put together the story after the fact. So bottom line, greater clarity is in the interest of all parties if they're acting in good faith.
It looks like we have a few minutes left for the Q&A portion of the program, and we have a couple of questions in. For those of you with questions, please submit your questions electronically via the Q&A panel in WebEx. As a reminder, if we don't get to your question during the program, we will make every effort to follow up with you after the program. First question I see on the screen is, should the breach notice say, quote, "We believe you are in breach of the contract"? How would you word it? Bob, how would you word what's a good way to word a breach notice or to frame a breach notice?
Well, I think that you want to identify what part of the contract has been breached, and you want to just basically say, look, the contract specifies X, and you have failed to meet the requirement, and then you describe the manner in which they failed to meet the requirement. You actually don't even have to use the term breach necessarily, at least in the very beginning of the relationship. Just a failure to meet this requirement. So you lay out what the requirement is, how they failed to meet it, and then a short explanation of why that failure to meet the requirement is a problem for your company. What is the adverse impact? And finally, a request that steps be taken that requirement be met within a certain period of time. Often which is specified in the contract. So it's a straightforward kind of business-like communication, no rhetoric, no threats, just basically this is the requirement, this is how it wasn't met, this is why it was important to us, and here's what we want you to do.
Second question was, in tip number 3, you suggested clarifying parts of the contract that are not clear. Is it enough to do this in written correspondence, or should it be done via a formal amendment to the agreement? From our perspective, we would much prefer a written amendment that resolves the matters in the best possible way. However, we also realize that there's only a certain amount of effort you can put into managing any particular contract, and also that there are places where you can, with relative ease, you can get a point established through a more informal mechanism like correspondence, and that you could not get established through an amendment. So amendment certainly preferred, but everything that you can do to create an evidentiary trail, a record, with clarity as to the obligations will be helpful. On the amendment point, it's a judgment call. If there's something brand new that you don't really have a hook in the agreement for, then I think you really need a formal amendment. But sometimes there's a hook. And for example, some language that the parties will mutually agree on reasonable performance standards, consistent with industry standards. So the agreement's there. The only question is, what is the performance standard that is consistent with industry standards? So you can, in that situation, identify what that is in communication, in correspondence, and get them to agree also in correspondence, and you just kind of filled in a blank. You haven't really amended the agreement. You've just made it clear that there's a meeting of the minds on a factual issue that this is a reasonable performance requirement. So it's kind of a case-by-case basis. But I agree with Brad. If you feel like there's not going to be any resistance or problem in just going through a formal amendment process, then that's the way to go. So I think that brings us to the end of our program. Let's have a couple of reminders and upcoming notes on upcoming programs. On behalf of Mayor Brown and Bob and me, thank you for your time. We very much hope you found this program useful. Please do be on the lookout for future invitations to our Technology Transactions webinar series. A recording and a link to the materials from this program will be distributed by email in the next day or two. And finally, if you have topic ideas for future programs, if you'd like a copy, one or however many copies of the laminated card with the 7 tips, please email us at either B. Peterson or Kriss at mayorbrown.com, or more generally at techtransactions@mayorbrown.com. Thank you again for your time and attention. We hope to see you on future webinars. And with this, we'll close the program. Thank you.